The American legal landscape for firearms has been thrown into unprecedented flux. In early 2025, the Department of Justice, under new leadership, reversed its long-held positions on gun control, launching a sweeping review of all federal regulations for potential Second Amendment infringements. Instead of defending gun laws, the DOJ now supports plaintiffs challenging them, aligning the federal government with gun rights advocates and leaving many existing laws in legal limbo. Courts are now forced to reevaluate cases with the government arguing against its own regulations, accelerating legal challenges and increasing the likelihood of Supreme Court intervention. What once seemed like settled law is now open for debate, with decades-old regulations facing their most serious challenges yet. The aftershocks of this reversal are just beginning, promising to reshape the rights and responsibilities of American gun owners for years to come. At the center of the DOJ's recent reversal was its evolving stance on firearm suppressors, devices often called silencers that are designed to reduce the noise and muzzle flash of a gunshot. These devices have been tightly regulated since the passage of the National Firearms Act of 1934, a law created during a time of heightened concern over organized crime and gun violence. For decades, the DOJ vigorously defended the NFA's strict regulation of suppressors, maintaining that these accessories were not protected by the Second Amendment and could be subject to heavy restrictions. But in a landmark move in 2024, the DOJ conceded that suppressors are indeed considered arms under the Constitution and thus fall under the protection of the Second Amendment, marking a monumental shift in federal policy. Rather than advocating for an outright ban, the DOJ now frames the NFA's registration process as a shall-issue licensing regime, where applicants who meet objective criteria must be approved, rather than being subject to arbitrary denial. Gun rights advocates, however, argue that the NFA's $200 tax, lengthy wait times, and complex paperwork create unconstitutional burdens on law-abiding citizens, making it difficult for many to exercise their rights. This new stance creates a paradox. While the DOJ now acknowledges suppressors are constitutionally protected, it continues to defend the very law that restricts their access, leading to ongoing legal and philosophical debates. The stage is set for a critical judicial showdown, as courts must now decide whether the NFA's requirements are a reasonable form of regulation or an unconstitutional barrier to the right to keep and bear arms. The DOJ's reversal on suppressors faced its first major test in the Fifth Circuit Court of Appeals. Despite the DOJ's new position, the court upheld the conviction of a man for possessing an unregistered suppressor, accepting the NFA as a shall-issue licensing system. The court reasoned that the NFA's objective process, background check, paperwork, tax, doesn't grant arbitrary power and is therefore constitutional. The ruling emphasized that the NFA is a structured process for legal acquisition, not a ban. This decision was a setback for those seeking deregulation, establishing that shall-issue licensing frameworks can survive Second Amendment scrutiny. The right to bear arms, the court affirmed, is fundamental but not exempt from objective regulation. The path to deregulation, it turns out, is far more complex than a simple DOJ policy change. All of this unfolds in the shadow of the Supreme Court's 2022 Bruen decision, a ruling that has sent shockwaves through the legal landscape surrounding gun rights and regulations. The Bruen decision fundamentally changed how courts analyze Second Amendment cases, shifting the focus away from balancing tests and toward a more historical approach. Now, under Bruen, the government must prove that any modern gun regulation is consistent with the nation's historical tradition of firearm regulation, specifically from the founding era. This so-called history and tradition test has quickly become the dominant standard in gun rights litigation, reshaping how courts evaluate challenges to gun laws. Lawyers and judges now find themselves searching for 18th-century analogs to justify or challenge modern laws, combing through centuries-old statutes and legal precedents. The Fifth Circuit's recent suppressor ruling is a direct response to Bruen engaging with its requirements in detail. The court focused on whether the National Firearms Act's registration process for suppressors could be considered a permissible shall-issue licensing scheme under the new standard. The reasoning was that if shall-issue frameworks are allowed for public carry of firearms, then similar objective systems for items like suppressors should also be constitutional. In other words, the court suggested that as long as the process is objective and non-discretionary, it can withstand constitutional scrutiny. This interpretation carves out space for licensing schemes that are based on clear criteria, rather than subjective judgment by officials. Still, gun rights advocates argue that the NFA's high taxes and lengthy wait times have no true historical precedent and continue to challenge these aspects in court. By framing the NFA as a modern analog to historical licensing systems, the court found a way to uphold the regulation within Bruin's strict test. This decision not only preserves the current regulatory framework for suppressors, but also signals how future courts might approach similar challenges. Ultimately, the Fifth Circuit's ruling sets a crucial precedent for future cases, shaping the ongoing debate over the limits and possibilities of gun regulation in America. For gun owners, the legal and political changes have created a confusing reality. The Fifth Circuit's decision means suppressors remain under the NFA, with buyers still facing the application process, background checks, and the $200 tax. However, the DOJ and ATF have dramatically improved processing times, reducing waits from months to days or even hours for electronic applications. While the legal barriers remain, the practical burden has eased, making NFA items more accessible in practice. This mixed outcome illustrates the complex interplay between legal doctrine and administrative action. Gun owners are in a better position than before, but far from the complete deregulation many hoped for. The fight for legislative reform like the Hearing Protection Act continues, but for now the regulatory process is faster, if not fundamentally changed. The DOJ's new posture extends far beyond suppressors, signaling a dramatic shift in federal gun policy that's sending shockwaves through the entire gun control landscape. These changes are rippling across the country, affecting gun owners, dealers, and lawmakers alike, and raising new questions about the future of firearm regulations. The department has ceased defending the ATF's controversial pistol brace rule, which had classified millions of commonly owned pistols as short-barreled rifles, subjecting them to strict regulation. This move signals its likely demise and represents a major win for gun owners and Second Amendment advocates who have long argued the rule was overreaching. The DOJ also dropped its defense of the federal law barring handgun sales to adults under 21, a restriction that has been in place for decades and was recently found unconstitutional by a federal court. After the court's decision, the DOJ's withdrawal leaves the law's fate uncertain, and creates a circuit split that is almost certain to draw the attention of the Supreme Court for a final ruling. In another major development, the DOJ is now siding with plaintiffs who are challenging state-level bans on so-called assault weapons, arguing that these rifles are in common lawful use for self-defense in sport, and that there is no historical precedent for prohibiting them in the United States. This marks a profound shift in federal legal strategy, with the federal government now actively supporting efforts to dismantle some of the nation's strictest state gun control laws, a move that could have far-reaching consequences. The DOJ's actions have accelerated the timeline for these contentious issues to reach the Supreme Court, potentially setting the stage for landmark decisions. The legal landscape is shifting rapidly, with new court challenges and policy reversals emerging almost weekly, and the potential for sweeping changes to gun laws nationwide has never been more real or more immediate. The DOJ's reversals have pushed American gun law into uncharted territory, with the constitutionality of many laws now in question. If the Supreme Court sides with the DOJ's new positions, it could trigger the largest rollback of gun control measures in U.S. history. The DOJ's actions are fast-tracking major cases to the Supreme Court, inviting decisive rulings on issues like assault weapon bans and handgun age limits. Lower court trends suggest outright bans are vulnerable, but objective, structured regulations may survive. The legal battles ahead will focus on historical tradition, with courts dissecting centuries-old statutes for modern relevance. The outcomes will have enormous consequences, potentially legalizing certain firearms nationwide while affirming the government's authority to regulate through objective processes. The tension between broad Second Amendment protections and historically consistent regulation will define this new era. We stand at a pivotal moment in American gun law, with the DOJ's dramatic policy reversal accelerating the legal battle over the Second Amendment. The DOJ's switch from defender to challenger of gun control laws has created a legal environment more favorable to gun rights than ever before. Yet, the Fifth Circuit's upholding of the NFA's suppressor requirements shows the legal tide hasn't turned completely. Courts may strike down broad bans but allow objective, non-discretionary licensing systems to stand. The likely demise of the pistol brace rule and potential Supreme Court victories could expand gun rights, but core NFA requirements remain secure for now. the future will be shaped by Supreme Court decisions, with rapid legal evolution and landmark rulings on the horizon. One thing is certain, the debate is far from over, and today's decisions will echo for decades to come.